Hi, welcome at Intellect YouTube channel. Today's topic, wanna talk about the crime and criminal justice. Crime is a behavior either by an actor or omission defined as statutory or common law as deserving of punishment. Although most crimes require elements of intent, certain minor crimes may be committed on the basis of strict liability, even in different defendants had no specific mindset with regard to the crime action. Crime and criminal justice. You must be able to define the concept of crime justice, explain information of criminal justice, explain the formal and informal criminal justice uh, processes. And the high profile crime courts help focus interact on the criminal justice system, which is CJS, I mean, sorry. The public relies on the agencies of the criminal justice system for protection and from complex criminal incidents and scams. Is a crime recent development? Crime in the cities, gang activities has seen a drastic shift. Tails, speckles, revives for control of the street. For example, in New York, Black Eagles, the Swim Angel, the Daybreak Boys, and the Boys competed for a dominance. For protection, the public supports development of a wide array of government agencies. The purpose is to control and prevent crime, to identify, apprehend, and bring to trial those whom violate the law and devises effective methods of criminal corrections. Uh, these agencies are made up of criminal justice system. A criminal justice system is the system of the law enforcement, justification, and, and correlation that is directly involved in the apprehension, prosecution, and the control of the charge with the criminal offenses. This in early 1829, the first police agent was created by London Metropolitan Police, created to keep the peace and identify and apprehend the criminal suspect. In 1967, President's Commission on Law Enforcement and Administration of Justice, the Crime Commission, Safe Streets and Crime Control Act of 1968, um, uh, provide the provides for the expenditure of federal funds for state and local crime control effects. This is a federal involvement. Uh, the evidence-based justice (EBJ) method system relies more on the scientific collection uh, of data to determine crime programs work and what policies could be adopted. EBJ therefore entails determining through the use of scientific method. There are principles on the screen. The principles of evidence-based justice, target audience, randomized experiments, intervening factors, measurement of success cost of effectiveness. When you talk about the contemporary criminal justice system, this is a system of social control that CJS can be involve seek to prevent or reduce outrageous behavior by apprehending adjudicating and sanctions law. Okay, in criminal justice system, we have three predominant of the criminal justice system, which is the law enforcement, which is the court and correctional service systems. Um, and these correctional service systems investigate in the aid of treatment and rehabilitation. Rehabilitation, the taking or for a crime for a criminal into jail. These three predominant components uh, is legislative, judicial, and executive. These all these three predominant we can start on legislative. It's define the law, shape the policy, judicially, when you talk about the judicial, you talk about the court, interpret existing laws, oversees criminal justice. Executive, you talk about the correctional, day-to-day operation of justice agents. There are two types of criminal justice. There is a formal and informal criminal justice. The formal criminal justice have many pro there are 15 processes that should be undergone when you are in the process of justice of criminal. These processes, other factors also influence decisions making race, class, and relative use cases processed through the entire system. Background deals and bargain justice. These are the processes on the screen. The one that is hiding will be defined in the video as a video is proceeding. There is initial contact, investigation, arrest, custody, charging, preliminary hearing. On the preliminary hearing, we on the next video we're gonna talk about the preliminary investigation, or on that how the preliminary investigation phase is connected. Talk about the arraignment, bail or detention, plea beginning, trial, education, sentencing, appeal, postpone, release, and other the last one that will be mentioned on the video. What is the purpose of investigating? Investigation, the purpose is to gather enough evidence to identify the suspect or a perpetrator for support in arrest. We have initial conduct. And the initial conduct offender is initial conduct with the criminal justice system take place as a result of police action. This is on the screen that are the actions that you see on the screen. Investigation to gather information to identify the perpetrator, understand the perpetrator's method and motive. When you talk about the perpetrator, we talk about the crime. Then, and the next in the video that will be followed, we're going to talk about the modus operandi, the system that is used, or the method that is used by the perpetrator to conduct a and we'll talk about the arrest. When we're talking about the arrest, we consider legal action when the police officer believes that there is a sufficient evidence, probably cause that a crime is being or has been committed, or before in the investigation, the investigator must confirm that the crime has been committed. For instance, as I said, we're gonna talk about another video that is gonna explain the preliminary investigation phase. In the present requirement, we're gonna talk about the custody, the protection from the unconstitutional abuse police power, SARS, illegal searches, and intimidating interrogations, right? To remain silent. And the next, we're gonna talk about the charging. Enough evidence is gathered. That means we can charge the perpetrator. The prosecutor decision evidence sufficient crime seriousness, case pressure, political issues, personal factors. On an enough evidence, there are many different type of evidence that can be subjected on the court during the proceedings. We're gonna talk about these type of evidence. That what are this type of evidence or we're talking about. On the screen, as you see, the charging processes and how it goes, and talk about the preliminary hearing or grand jury. This preliminary hearing was created in England in the 12th, fifth, I mean in the 12th, fifth um, century, practice in the colonies. U.S. Constitutional mandate that before a trial can take place, the government must first show probable case. Read on the screen. Lower court conduct an open hearing on the merit of the case, referred to as probable hearing. Arraignment is a defendant will be arraigned, brought before the court that will hear the case. Formal charges read constitutional rights are followed by an initial plea, guilty or not guilty. If you find guilty, you will be arrested. If you are not found guilty, you will be released. A trial date, bail issues, consideration. When you talk about the bail, we talk about the money bond leaves to ensure that the return of a criminal defendant for trial, allowing the defendant to remain in the community prior to trial. In other way, you are saying that instead of arresting, instead of putting me in a custody, you can use this money or you can hold this type of finance as you call about bail or detention. When I talk about a plea bargaining, guilty plea exchange for reduced charges or lenient sentence. A trial. Talk about a trial or adjudication. Criminal trial held before a judge or jury decide whether the prosecution evidence is against the parent. As we're gonna talk about the type of evidences in the following video. Sentencing, how to sentence. It is accused for found guilty. She or he will be retained in the court for sentencing. As I've mentioned, appeal is a disapprove the decision of jury. Appellate court review such rule. Defendant be given a new trial in order his or her outright release. Let's talk about the release. Talk about Carol or pardon, ending time for good behavior. Formal in informal criminal justice process. Um, Formal rules are followed to create smoothly functioning disposition of cases from the arrest to punishment. Criminal justice system have again informal the process, which is recognize the informal authority exercised by an individual at each stage of the criminal justice process. The informal criminal justice system, uh, the courtroom work model and the wedding cake model, which means we have two models. This is a courtroom. We're going to talk about a courtroom. Cooperative ventures in which all parties get together to work out of the deal. Cooperation, not conflict, is the norm, made upon of the prosecutor, defendant, attorney, judge, and the other court personnel. function of streamline the process of justice through the existence to as existence of the judge and other court personnel. This is the courtroom work. The goal is to process the case rather than to seek the justice, which means the justice is follow behind the courtroom work. The wedding cake model, Samuel Walker was the founder, came up with a dramatic way of describing the informal justice process. What are the goals and purposes of the criminal justice? We have only six goals in the perspective of justice. To control perspective is a control perspective, rehabilitation, equal justice, restorative. Restorative is to bringing back or claiming back of the stolen goods during the crime, during the scene of transgression. Due processes perspective and non-intervention perspective. Mm. Crime controls perspective prevent through the judicious use of criminal sanctions. They do not want illegal technicalities. Argue that all policies may sometimes use facility technique that abridge civil liberties, legal and road process. I'm gonna show it on the screen as you see. Let's talk about rehabilitative perspective. Justice seen as a means of caring for and treating people who cannot manage themselves. This is the process of called rehabilitation. Uh, Rehabilitation perspective as a crime and control by giving people the means to improve their lifestyle, assume people's um, at the mercy of social, economic, and the interpersonal conditions. Criminal themselves are the victims due to process. Perspective, treating all those accused of crime fairly. No harm should be conducted. Use of discretion should be strictly monitored. Attending for civil rights. When you talk about the non-intervention perspective, talk about the non-aspect intervention perspective. It's believed that justice agents will be limit their involvement with crime defendants. If and less stigmatizing, less repeat offenders, and the institutionalization, which is under the non-intervention perspective. Okay, then the equal justice perspective, all people should receive the same treatment under under the law. Racial animals model a mental imaginary typical offender based on the principles just a desert or on video we have talked about the principles of conducting the investigation, which is the local exchange principle. Real restorative justice is promote a peaceful and just society, aims for peacemaking and not punishment. uh, Crime encouraging rather than crime discouraging. Offender to appreciate damages reintegrated into society. This resolution and conflicts between the offender and victim. By understanding the justice system today require analyzing a variety of occupational roles, institutional processes, legal rules, and administrative doctrine. Please subscribe on the subscribe button. Please share the video for more notifications on this YouTube. Thank you for watching.